Few disputes get as emotional as those between landlords and tenants, rent arrears, repairs, deposits, or eviction notices. What begins as a legal question often turns into personal frustration. That's where mediation comes in. Instead of fighting in court, lawyers guide both sides to find a practical solution. But here's the challenge: language matters just as much as law. In mediation, every word can calm the room or inflame it. Lawyers must be precise, neutral, and persuasive, using English that de-escalates conflict while protecting their client's position. That's exactly what we'll practice today. And if you want to take this further, practicing real mediation role plays, getting expert feedback, and joining a global network of lawyers, make sure to join our legal English community in school. You'll find the link in the description. By the end of today's lesson, you'll know how to handle mediation between landlords and tenants using legal English. We'll start with the vocabulary for tenancy disputes, the kind of terms lawyers rely on when addressing arrears, repairs, eviction notices, or breaches of covenant. Next, we'll work with mediation language, phrases that de-escalate conflict, keep the discussion neutral, and ensure both sides feel heard. Then we will move on to structuring settlement offers and counteroffers in English, so your proposals sound professional and enforceable. Finally, we'll explore legal phrases such as good faith negotiation, mutually acceptable terms, without prejudice, and binding settlement. These expressions will help you guide a mediation toward a practical and durable resolution. By the end of this class, you'll be ready to step into a landlord-tenant mediation and communicate with confidence and authority. Let's begin with a real-world story. A tenant has fallen 3 months behind on rent. At the same time, the apartment's heating system has broken down, and the landlord has refused to pay for repairs. The tenant insists, "I won't pay until you fix it." The landlord replies, "If you don't pay, I will evict you." Tension escalates. Lawyers are called. Both sides prepare for court. But instead of a long, expensive trial, the judge orders the parties into mediation. Now the challenge begins. The tenant feels the landlord is exploiting their position. The landlord believes the tenant is breaching the tenancy agreement. Both sides have lost trust. As mediators, or lawyers representing clients in mediation, how do we shift the conversation? Should we begin with money, with repairs, or with rebuilding trust? This warm-up story introduces the type of disputes we'll be working on in this lesson. Disputes where law and language combine to either escalate conflict or move it toward resolution. The foundation of any landlord-tenant relationship is the tenancy agreement. This is the contract that defines the rights and responsibilities of both parties. Imagine our warm-up case. The landlord points to the tenancy agreement. The tenant must pay rent on time, regardless of repairs. The tenant replies, "The agreement also requires the landlord to maintain the property in good condition." A tenancy agreement can cover rent and payment dates, repairs and maintenance, deposit and return conditions, rules for termination or eviction. In mediation, lawyers constantly return to this document, but they don't just read the clauses, they interpret them in a way that balances fairness with practicality. You'll hear key collocations such as draft a tenancy agreement, breach of the tenancy agreement, and terms of the tenancy agreement. For lawyers, using this phrase correctly signals professionalism. It reminds both sides that mediation is not about emotion alone. It is anchored in the legal framework of the tenancy agreement. One of the most common flashpoints in landlord-tenant disputes is rent arrears, unpaid rent that builds up over time. In our warm-up case, the tenant has not paid for 3 months, and the landlord argues rent arrears are a breach of the tenancy agreement. The tenant responds, "I withheld rent because the property was uninhabitable." This single phrase, rent arrears, carries heavy consequences. For landlords, it justifies eviction. For tenants, it may be used as leverage to demand repairs. In mediation, lawyers must use the phrase carefully. Instead of accusing, they might reframe it. There is a dispute about rent arrears due to unresolved repair issues. You'll hear key collocations such as fall into rent arrears, clear the arrears, ongoing arrears dispute. Mastering this phrase shows you can discuss financial conflict neutrally, focusing on resolution rather than blame. When rent arrears grow or rules are broken, the landlord may issue an eviction notice. This is not just a letter, it is a formal legal step that begins the process of removing a tenant from the property. In our mediation story, the landlord warns, if you do not pay within 10 days, I will serve an eviction notice. The tenant feels threatened and conflict escalates. Why does this term matter? Because the eviction notice is often the turning point. For landlords, it is a legal remedy. For tenants, it is a trigger for defense, negotiation, or counterclaims. In mediation, lawyers must handle this phrase with care. Instead of framing it as punishment, they can reframe it as part of the negotiation. For example, the eviction notice has been served, but we are here to explore whether a settlement can avoid court. Key collocations include serve an eviction notice, challenge an eviction notice, or withdraw an eviction notice. It's important to use this phrase correctly because it shows authority. But in mediation, tone and neutrality are just as important as the law itself. At the end of almost every tenancy, there is one final battle: the deposit dispute. The tenant says, I left the apartment in good condition. I want my deposit back. And the landlord replies, you caused damage and left unpaid bills. I'm keeping part of the deposit. Deposit disputes can cover unpaid rent, repairs or cleaning costs, normal wear and tear versus actual damage. It's important to notice the difference between the two. In mediation, this term comes up constantly. The deposit may be small compared to long-term arrears, but symbolically it matters. It represents fairness, closure, and trust. Instead of framing it as accusation, a mediator might say, there is a deposit dispute. Let's separate what is a legitimate cost from what is contested. Tenancy agreements often contain more than just rent clauses. They include covenants, binding promises between landlord and tenant. A breach of covenant occurs when one side fails to follow these obligations. In our mediation case, the landlord claims the tenant breached the covenant by keeping pets in the apartment. And the tenant counters the landlord breached the covenant to provide heating and repairs. Breach of covenant can cover unauthorized subletting, causing damages to property, failure to maintain essential services, or restricting use of the property against the agreement. In mediation, this phrase is crucial because it shifts the discussion from blame to contractual analysis. Instead of personal accusations, the mediator can frame it neutrally. There are allegations of breach of covenant on both sides. Let us examine each obligation carefully. You will hear key collocations such as alleged breach of covenant, remedy for breach of covenant, and serious breach of covenant. This phrase elevates the discussion. It reminds everyone that mediation is not just about emotions, but about legal duties defined in writing. When a landlord decides to recover property through the courts, they begin possession proceedings. This is more than just an eviction notice. It is a formal legal process to reclaim the property. In our mediation scenario, the landlord threatens, if you don't clear the arrears, I'll start possession proceedings. The tenant feels the pressure because once proceedings begin, costs rise and the risk of losing the home becomes real. Possession proceedings usually involve filing a claim in court, a hearing before a judge, an order granting or denying possession. In mediation, this phrase is often used as leverage, but skilled mediators shift the focus. For example, they can say, possession proceedings may be avoided if both sides agree to a payment plan or repairs. Mediation only works if both sides are willing to negotiate in good faith. This means more than just showing up to the session. It requires honesty, transparency, and a genuine effort to resolve the dispute. In our landlord tenant case, the mediator observes the landlord is threatening eviction but refuses to discuss repairs. The tenant is demanding a deposit return but ignores arrears. Neither is practicing good faith negotiation. The mediator steps in. To move forward, both sides must engage in good faith negotiation. That means considering real compromises, not just repeating demands. Good faith negotiation is recognized in many legal systems as both a duty and a standard. If one side negotiates dishonestly, hiding facts, refusing to listen, or acting only to delay, mediation is unlikely to succeed. You'll hear phrases such as negotiate in good faith, obligation of good faith, and failure to negotiate in good faith. For lawyers, this phrase is critical because it is often written into agreements and settlements. It also sets the professional tone. Mediation is not about winning, it is about solving. At the heart of mediation is finding mutually acceptable terms, conditions that both parties can live with, even if neither side gets everything they want. In our case, the mediator suggests the tenant pays part of the rent arrears now. The landlord agrees to carry out repairs. The deposit is adjusted to reflect damage fairly. Neither party is fully satisfied, but both accept the compromise. These are mutually acceptable terms, not perfect, but practical. Why does this phrase matter? Because mediation isn't just about victory, it's about resolution. Judges enforce rights, mediators help design agreements. Lawyers must therefore learn to reframe demands into terms that both sides can accept. You will hear key collocations such as negotiate mutually acceptable terms, reach terms acceptable to both parties, and failure to agree on mutually acceptable terms. This phrase shows balance and neutrality. It signals that the goal is not to punish, but to close the dispute in a way that works for both sides. In mediation, tone is as important as content. Direct statements like you must pay or I refuse to fix this escalate conflict. That's why lawyers and mediators often use indirect language to soften proposals. For example, instead of you need to pay the arrears now, the lawyer might say, perhaps we could consider a payment plan over 3 months. Instead of you refuse to repair the heating, the mediator might suggest, would it be possible to schedule repairs alongside a revised rent agreement? These forms don't weaken the point, they reduce resistance, making it easier for the other side to engage. Why is this grammar important? Because mediation is about de-escalation. Indirect language allows lawyers to guide discussions towards solutions without triggering defensiveness. In advanced legal English, knowing when and how to soften your phrasing is a professional skill that can make or break a mediation. In mediation, how you frame proposals can decide whether they are accepted or rejected. Direct commands often fail. Instead, lawyers use modal verbs, could, might, or should, to present offers as options, not ultimatums. For example, instead of saying the tenant will pay everything now, you can say the tenant could clear half the arrears now and the rest later. Instead of the landlord must repair the heating immediately, reframe it. The landlord might agree to repairs within 14 days if rent is brought up to date. Modal verbs create space. They signal flexibility, showing that terms are negotiable. This encourages cooperation instead of resistance. Why does this matter for lawyers? Because mediation is not about forcing outcomes, it is about exploring possible settlements. Modal verbs help you sound professional, balanced, and constructive. In legal English, using modal verbs strategically lets you propose solutions that both sides can consider seriously. Mediation often works through conditional offers. One side agrees to act only if the other side responds. In our case, the landlord says, if the tenant pays 2 months of arrears, I will withdraw the eviction notice. The tenant replies, if the repairs are carried out, I will pay full rent from next month. This grammar, using if clauses and had if plus past perfect, creates logical links between actions and concessions. It turns demands into structured negotiations. Conditional offers are persuasive because they show fairness. Each side gives something, each side gains something. Why is this important? Because mediation thrives on balance. Conditional language provides a legal and linguistic framework for compromise. For advanced legal English, mastering this structure means you can draft and present settlement proposals clearly, proposals that judges, mediators, and clients will understand as fair and enforceable. In mediation, not every agreement is final on the spot. Often, the parties reach a settlement in principle, a handshake deal that sets the framework but still requires formal drafting and legal review. Imagine our landlord tenant case. After hours of negotiation, both sides agree. The tenant will clear part of the arrears, the landlord will complete repairs, and the tenancy will continue. But before it's binding, the lawyers say, we have a settlement in principle, but we need to draft the written agreement. Why is this important? Because mediation relies on trust, but law requires precision. A settlement in principle shows progress. It means the dispute is essentially resolved, but it also reminds parties that details matter. You'll hear key collocations such as reach a settlement in principle, record a settlement in principle, convert a settlement in principle into a binding settlement. For lawyers, using this phrase shows you understand the stages of resolution. First, the negotiation breakthrough, then the formal legal conclusion. One of the most important questions in mediation is whether the deal will hold outside the room. This is where the concept of enforceability of terms becomes critical. Imagine our landlord tenant mediation. The tenant agrees to pay arrears in installments, and the landlord agrees to carry out repairs. But unless the agreement is signed, clearly written, and legally valid, either party could later walk away. The mediator reminds them the enforceability of terms depends on proper drafting. If you want this settlement to hold in court, it must be clear, precise, and signed by both parties. Why does this matter for lawyers? Because clients often think a verbal deal is enough. Lawyers know better. Only enforceable terms protect the client if the other side defaults. You'll hear key collocations such as question the enforceability of terms, ensure the enforceability of terms, settlement unenforceable for lack of formality. This phrase highlights a lawyer's role, turning compromise into certainty by ensuring the settlement is not just agreed, but enforceable. The ultimate goal of mediation is not just discussion, but a binding settlement. A binding settlement is more than an agreement in principle. It is the final, signed contract that courts will recognize and enforce. In our landlord tenant case, after hours of negotiation, the parties agree. The tenant will repay arrears in monthly installments. The landlord will complete repairs within 30 days. Both will continue the tenancy under revised terms. Once signed, this becomes a binding settlement. If either side fails to comply, the other can return to court to enforce it. Why is this phrase important? Because mediation only succeeds if the result has legal force. Without a binding settlement, the process risks being a wasted effort. You will hear key phrases, collocations such as conclude a binding settlement agreement, and enforce a binding settlement. For lawyers, this phrase signals the moment when negotiation becomes law, when compromise becomes enforceable justice. One phrase that often appears in landlord tenant settlements is vacant possession. Vacant possession means that when the tenant leaves, the property must be completely clear. No occupants, no personal belongings, no continuing claims to use the space. In our mediation case, the landlord agrees to return part of the deposit if the tenant moves out early. The condition, vacant possession within 14 days. This ensures the landlord can relet the property immediately without obstacles. Why does this phrase matter? Because disputes often arise when tenants leave furniture, personal items, or even unauthorized subtenants behind. Without vacant possession, the landlord does not regain true control. You'll hear key collocations such as deliver vacant possession, vacant possession order, failure to provide vacant possession. For lawyers, this phrase is technical but essential. It transforms a vague promise to leave into a clear legal obligation, protecting landlords and clarifying tenants' responsibilities at the close of tenancy. Let's put the lesson into action with the full mediation scenario. A tenant is 3 months in rent arrears. The landlord, frustrated, has served eviction notice. At the same time, the tenant claims the landlord breached the covenant to provide heating during the winter. The dispute is referred to mediation. The mediator begins carefully, using indirect language. Perhaps we should consider a payment plan. Would it be possible to schedule repairs alongside revised rent terms? The tenant responds with a conditional offer. If repairs are completed, I will resume full rent payments. The landlord frames his own position with a modal proposal. I might agree to reduce arrears if the tenant vacates early. After several hours, both sides agree to a settlement in principle. The tenant will repay arrears in installments. The landlord will repair the heating within 30 days. The tenancy will continue until summer, when the tenant will leave. To ensure certainty, the lawyers discuss the enforceability of terms and draft a binding settlement. The condition for moving out: the tenant must deliver vacant possession. This mediation shows how legal English vocabulary, grammar, and phrases combine in practice. Instead of escalation, the language of mediation moves the dispute from threat to resolution. Let's review what we achieved today. You built advanced vocabulary for landlord tenant disputes, from tenancy agreements and arrears to eviction notices, deposit disputes, and possession proceedings. You practice grammar that gives lawyers control in mediation, indirect language to reduce tension, modal verbs to present flexible proposals, and conditional structures to balance concessions. You also mastered 4 technical legal phrases: settlement in principle, enforceability of terms, binding settlement, and vacant possession. Terms that make mediation outcomes professional and enforceable. Finally, through our case story, you saw how all of these tools work together, how a heated landlord tenant conflict can move from threats of eviction to a binding settlement. This is advanced legal English in practice: precise vocabulary, persuasive grammar, and legal phrasing that turns conflict into resolution. If you'd like to keep practicing with real case simulations and get expert feedback, join our legal English community where we turn lessons like this into live practice. Click on the link below.